So I want to talk a little bit about the cornerstones of an effective estate plan, what goes into creating a valid will, the different types of wills, some of the things that you should be considering. So really, it's not going to come as a shock that the cornerstone of an effective estate plan is, in fact, having a valid will. Also having powers of attorney in place. But since this is more a will-focused talk, I'll leave aside the topic of powers of attorney for today. But I will say, if you're creating a will, at the same time, go ahead and create your powers of attorney. And powers of attorney are the things that come into play while you are still alive. So there's a power of attorney for property. So it's handing decision-making over to another person or perhaps a trust company to handle your property, which are your assets, in case something happens to you or you're incapacitated and can no longer do that yourself. There's also a power of attorney for health. So if something happens and decisions need to be made in terms of your health care, then there is a valid legal documentation in place to allow people who care about you to make decisions about your health care. Creating a valid will. Each province has its own requirements as to what constitutes a valid will. In most, there's there's either a formal will or a holographic will. Generally, a will is deemed valid and only deemed valid if it's in writing, if it's signed at the end by the testator, and if it is signed in front of two witnesses, and the witnesses should not be or cannot be people who are in the will as beneficiaries. A holograph will is just a fancy word for a handwritten will. And these tend to be created in emergency situations. They tend to be very short and sweet. They're not valid across the country. BC and PEI do not recognize holographic wills. It adds to cost, it adds to delay. There can be misunderstandings, and holographic wills on their own, they can be ambiguous. If wording is off, it's a little incorrect, then it can lead to disputes. And we'd really like the process to go as quickly and easily as possible. Digital wills are another thing that have come across, and as technology continues to advance, the need has grown for the law to be current and responsive to technological development. BC was the first Canadian province to pass legislation that allowed for like a DocuSign, e-signing, and also video witnessing. And this grew out of emergency provisions that were undertaken during the pandemic. And so those laws came into effect in 2021, and we are seeing an uptake in the digital side. And as I actually speak of digital side, I just want to put in a little bit of a little plug too, that when you're looking at estates, you also have to include your digital assets. So you've got PC Optimum points or Avion points or a Facebook account or an Instagram account or iCloud and Google Drive. None of these things I had to worry about with my parents because they couldn't turn on a computer, but more and more of us are digitally savvy. So these form some of our assets. So that should also be put in the will. So we're evolving into the digital age. I'd like to stress the difference between a digital will as permitted under legislation, such as that's provided by Willfora, and that of online will kit providers. The latter, the will kit provider, it's a digital option to create your will. However, it only will be valid if it meets those formalities, such as a wet signature, witnesses, and etc. So those are different types of will. Why do you need one? If you die without a will in Canada, then you are considered to have died intestate, and somebody has to apply to court to be appointed to administer your estate. Legislation determines who has priority to apply to be executor, and it also dictates who will receive the assets. So legislation is forming your estate plan, not you. Minors, if there are any minors that are beneficiaries, they're going to inherit at the age of majority, regardless of whether that's the best thing for them, whether they are equipped to handle an inheritance. You can't delay their receiving it until an age that you would deem them more capable of handling it. Generally, the ones you leave behind are given no opportunity to do any sort of strategic planning, whether it tax or otherwise, around who gets the assets, when they get those assets, or how they get those assets. Just to reiterate, the distribution of your estate and your choice of the person to administer the estate may not reflect your wishes. Your assets will be distributed arbitrarily according to applicable provincial intestacy laws. Again, not necessarily reflecting how you would like them to be distributed. You're going to lose the opportunity to establish trusts for minors, subsequent spouses, perhaps special needs beneficiaries. You will have no ability to appoint guardians for any minor children. You'll forfeit any opportunity to engage in income tax or probate planning, and it's generally more costly and time-consuming to settle an estate that is intestate. So I want to have a quick discussion on some of the considerations you might have with regard to beneficiaries, including if you have philanthropic intentions. There's been some confusion, read a lot of confusion regarding how charitable donations are going to be treated with regard to alternative minimum tax and donation of securities in kind when you donate stocks, bonds, mutual funds, etc., to a charity. So if we want to sort of recap the good old days, prior to the 2023 budget, you would not realize any capital gain on any security that you had donated to charity when you had donated it in kind, which is a win-win for the charity and for the donor. No capital gains payable incentivize donors to donate securities directly rather than sell them, pay the capital gains tax, and then donate whatever was left over. So the donor, you received a larger deduction, thereby reducing your overall tax bill. The charity typically received a larger donation. Everybody's happy. And so in 2023, the federal government proposed changes to cut the donation tax credit from 100% to 50%, and then also levy a 30% capital gains inclusion rate on the donation itself, which would then be included in income for the purposes of calculating the alternative minimum tax liability. Now we've moved forward another year. We've got the 2024 budget, still hasn't been passed, but is expected to. They've proposed a slightly modified version of this, where they've amended the proposed cap on the donations tax credit from 50% to 80%, but the capital gains inclusion rate of 30% has remained. Again, legislation hasn't been passed yet, so there's a lot we still don't know. But one thing that has remained the same with regard to attempting to mitigate or minimize your AMT is that it doesn't apply on death. So donations made through your estate will not be affected by those proposals. And if philanthropy is important to you, then I would suggest it is important to consider adding your favorite charities to your will as part of your overall estate plan. Everyone's situation is different, and there are different methods that you can use to ensure that your favorite charity benefits from your intentions. And there are ways to structure the will properly and different tools you can use to maximize the tax efficiency of the donation. Personally, I've incorporated charitable giving into my estate planning, and I've named Trillium Health Partners Foundation as a beneficiary. The hospital has been there for me. It's cared for my father at his end of life. Other members of my extended family, one of my sons was born here. And I just want to ensure that the care that I've received can be received by others well into the future. I just want to reiterate that you should always speak with your professional advisors, whether it's your lawyer, your accountant, your wealth advisor, to ensure that your wishes are reflected in action appropriately. And if you don't have those advisors or need an introduction, I would be happy to sit down with you and help you out in whichever way I can. I do work with a network of professionals, and we integrate all our services together. So I would be happy to meet with you, and Nicole has my information if anyone needs it.